Hello, law students. This is Mrs. Politsky, and I have notes for Chapter 6, Offer and Acceptance, Section 1, the Creation of Offers. So before we begin, make sure that you have your packet in front of you and follow along. So, the creation of offers. Anytime we have an agreement that the courts will enforce for the basis of all economic activity, for the most part, we have what is known as a contract. Okay? A contract, for the most part, results from an exchange of some kind of valuable promise. And there are some different requirements. And what we're going to do is go through 6 of the big requirements for a contract. First, you have to have offer and acceptance, hence the name of our chapter. An agreement must be serious, meaning that anyone who's kind of just finding out information about maybe price and such, it's not necessarily a serious offer. What they're kind of determining is a value, perhaps. So you must be prepared to enter into a contract when we're looking at offer and acceptance. A definite offer and acceptance is basically on mutual and satisfactory terms. So there will be an individual or a party that is wanting to make a purchase and an individual or a party that is wanting to make a sale. The second item that you need for a contract is a genuine assent. This is not based on one party deceiving another on any kind of issue or a mistake. So, for example, price. If there's a misunderstanding on that, then we might not have genuine assent. Or the condition, let's say, of the item that is to be sold, okay, or maybe the term, how long that offer is available for and such, okay. You can't use unfair pressure, so I can't force someone to enter into an offer, like putting pressure on them, coercing them. All of that would defy the concept of a genuine assent. The third item is legality. Whatever you are agreeing to contract for, it's got to be legal. So an agreement to commit a crime or an agreement to purchase illegal drugs or any item that is illegal, perhaps because of an age issue, that is not a valid contract. The fourth item, consideration. This is an agreement that involves both sides receiving something of a legal value as a result of the transaction. So if I'm purchasing a car, I would be willing to give a monetary amount in exchange for the car itself. The fifth item, capacity. So having a certain knowledge of what you're contracting to have complete enforceability, an agreement, for an agreement, the parties that are contracting must contract for themselves, rather than being obligated to use like a parent or a legal representative. So in Nebraska, we're probably looking at an individual who's probably reached the age of majority. Otherwise, this individual may have emancipated themselves, but they have to know what they are contracting to. And then finally, the sixth item is the item should be in writing. Some agreements must be placed in writing to be fully enforceable in the court. Not all contracts have to be in writing. There are some contracts that can be a verbal agreement. But if you're talking about like buying a home or buying a car, anytime that you're using borrowed money, perhaps through a bank, you're probably going to have this in a writing. Okay, the individual who makes an offer is known as an offerer. And the person whom the offer is made is the offeree. So valid offers. The offerer must appear to intend to create the legal obligation. So again, if you're just finding out a value of an item, maybe, kind of asking questions about perhaps maybe the merchandise that one wants to buy, that's not necessarily entering into a contract. It's not an offer. What you're doing is kind of determining maybe some of the factual sides. The terms must be definite and complete. So, when we're talking about dates, so if we're going to sell an item, we might have the date posted, we may have the price, those kind of things. If it's something that has to be delivered, perhaps maybe even the estimated delivery date. And then the offer must be communicated to the offeree. So if nothing is communicated, it's not really an offer. Okay. Expressions of intent to create the legal obligation. There is something known as the test of a reasonable person. This is kind of an objective legal test. A lot of times it's used by jurors and judges to determine whether the offerer has shown some kind of intent to contract. Looking for the appearance or the conduct to indicate that an individual intends to be or to follow through with a contract. So it could mean that you're willing to proceed maybe with terms of like financing, if you're talking about buying a car or buying a house, perhaps maybe even proceeding with some of the paperwork. All of this looks, for the most part, that an individual intends to follow through. Facts and circumstances. Were the offerer's words and conduct relevant to the facts and circumstances? Were the words spoken in anger or jest or terror? So I might have an old car, might not necessarily be working very well, and I might be driving down the road with my friend, and I might say, man, I would sell this car for $500. And my friend might hear that and say, deal. If I'm upset or angry, that is not necessarily an offer. I may be just frustrated, I'm just venting. So we have to look at the facts and circumstances. Preliminary negotiations. Does one party state tentative terms inviting others to make an offer? So this is kind of like when we go through and we're trying to find perhaps maybe a value. So if you're talking about individuals who are wanting to buy a house, there might be a price the realtor might be working with. You look at the price, you might maybe return an offer that might be below that price, with the hopes of maybe negotiating the price to a reasonable level. The fourth item, social agreements. Social agreements are not necessarily legal obligations, so agreeing to meet someone at a certain time is not necessarily a legal obligation. Offers must be complete and clear. The terms must be complete and clear. Here we go. To allow the court to determine what the parties intended and identify the parties' legal rights and duties. So complete, meaning that we have information about price, date, delivery. We have clear, which basically means the terms are identified and maybe are pointed out to the individual who is in the process of contracting. Implied terms. Anytime that is implied, it may not necessarily be spoken, but it is assumed. So the terms should be implied by law or common business practice. It might not necessarily be stated, but people are intending to follow through with those items. And then advertisements. Advertisements, regardless of where they appear, TV, magazines, so forth, generally does not really negate an offer. But it gives an invitation for people to come in and perhaps maybe do business and maybe make an offer at a later date. Offers must be communicated to the offeree. A person who is not the intended offeree cannot accept the offer, nor can a person accept an offer without knowing that it has been made. So, if I'm not home and someone answers the phone, and let's say somebody is wanting to make a contract, that other person cannot speak for me. Only I can speak for myself in that position of being an offeree. A reward offer that is made to certain persons or even to the general public cannot be accepted by someone who has never seen or heard the offer. Thank you very much.